Exploitation. 1. Prohibition of traffic in human beings and forced labor. Article 23 prohibits traffic in human beings, beggar, forced labor, and other similar forms of forced labor. Any contravention of this provision shall be an offense punishable in accordance with law. This right is available to both citizens and non-citizens. It protects the individual not only against the state but also against private persons. The expression traffic in human beings include a. Selling and buying of men, women and children like goods. B. Immoral traffic in women and children, including prostitution. C. Devadasis. And D. Slavery. To punish these acts, the Parliament has made the Immoral Traffic Prevention Act 13, 1956. The term beggar means compulsory work without remuneration. It was a peculiar Indian system under which the local zamindars sometimes used to force their tenants to render services without any payment. In addition to beggar, the Article 23 prohibits other similar forms of forced labor like bonded labor. The term forced labor means compelling a person to work against his will. The word force includes not only physical or legal force but also force arising from the compulsion of economic circumstances, that is, working for less than the minimum wage. In this regard, the Bonded Labor System, Abolition Act, 1976, the Minimum Wages Act, 1948, the Contract Labor Act, 1970 and the Equal Remuneration Act, 1976 were made. Article 23 also provides for an exception to this provision. It permits the state to impose compulsory service for public purposes, as for example, military service or social service, for which it is not bound to pay. However, in imposing such service, the state is not permitted to make any discrimination on grounds only of religion, race, caste or class. 2. Prohibition of employment of children in factories, etc. Article 24 prohibits the employment of children below the age of 14 years in any factory, mine or other hazardous activities like construction work or railway, but it does not prohibit their employment in any harmless or innocent work. The Child Labor, Prohibition and Regulation Act, 1986, is the most important law in this direction. In addition, the Employment of Children Act, 1938, the Factories Act, 1948, the Mines Act, 1952, the Merchant Shipping Act, 1958, the Plantation Labor Act, 1951, the Motor Transport Workers Act, 1951, Apprentices Act, 1961, the Bidi and Cigar Workers Act, 1966, and other similar acts prohibit the employment of children below certain age. In 1996, the Supreme Court directed the establishment of Child Labor Rehabilitation Welfare Fund in which the offending employer should deposit a fine of 20,000 rupees for each child employed by him. It also issued directions for the improvement of education, health and nutrition of children. The Commissions for Protection of Child Rights Act, 2005 was enacted to provide for the establishment of a national commission and state commissions for protection of child rights and children's courts for providing speedy trial of offenses against children or of violation of child rights. In 2006, the government banned the employment of children as domestic servants or workers in business establishments like hotels, dhabas, restaurants, shops, factories, resorts, spas, tea shops and so on. It warned that anyone employing children below 14 years of age would be liable for prosecution and penal action. The Child Labor, Prohibition and Regulation Amendment Act, 2016, amended the Child Labor, Prohibition and Regulation Act, 1986. It has renamed the Principal Act as the Child and Adolescent Labor, Prohibition and Regulation Act, 1986. Right to freedom of religion. 1. Freedom of conscience and free profession, practice and propagation of religion. Article 25 says that all persons are equally entitled to freedom of conscience and the right to freely profess, practice and propagate religion. The implications of these are a. Freedom of conscience, inner freedom of an individual to mold his relation with God or creatures in whatever way he desires. B. Right to profess, declaration of one's religious beliefs and faith openly and freely. C. Right to practice, performance of religious worship, rituals, ceremonies and exhibition of beliefs and ideas. D. Right to propagate, transmission and dissemination of one's religious beliefs to others or exposition of the tenets of one's religion. But it does not include a right to convert another person to one's own religion. Forcible conversions impinge on the freedom of conscience guaranteed to all the persons alike. From the above, it is clear that Article 25 covers not only religious beliefs, doctrines, but also religious practices, rituals. Moreover, these rights are available to all persons, citizens as well as non-citizens. However, these rights are subject to public order, morality, health and other provisions relating to fundamental rights. Further, the state is permitted to regulate or restrict any economic, financial, political or other secular activity associated with religious practice, and b. provide for social welfare and reform or throw open Hindu, religious institutions of a public character to all classes and sections of Hindus. Article 25 also contains two explanations. 1. Wearing and carrying of kirpans is to be included in the profession of the Sikh religion, and 2. The Hindus, in this context, include Sikhs, Jains and Buddhists. 14. 2. Freedom to manage religious affairs. According to Article 26, every religious denomination or any of its sections shall have the following rights. A. Right to establish and maintain institutions for religious and charitable purposes. B. Right to manage its own affairs in matters of religion. C. Right to own and acquire movable and immovable property. And D. Right to administer such property in accordance with law. Article 25 guarantees rights of individuals, while Article 26 guarantees rights of religious denominations or their sections. In other words, Article 26 protects collective freedom of religion. Like the rights under Article 25, the rights under Article 26 are also subject to public order, morality and health, but not subject to other provisions relating to the fundamental rights. The Supreme Court held that a religious denomination must satisfy three conditions. A. It should be a collection of individuals who have a system of beliefs, doctrines, which they regard as conducive to their spiritual well-being. B. It should have a common organization. And C. It should be designated by a distinctive name. Under the above criteria, the Supreme Court held that the Ramakrishna Mission and Ananda Marga are religious denominations within the Hindu religion. It also held that Aurobindo Society is not a religious denomination. 3. Freedom from taxation for promotion of a religion. Article 27 lays down that no person shall be compelled to pay any taxes for the promotion or maintenance of any particular religion or religious denomination. In other words, the state should not spend the public money collected by way of tax for the promotion or maintenance of any particular religion. This provision prohibits the state from favoring, patronizing and supporting one religion over the other. This means that the taxes can be used for the promotion or maintenance of all religions. This provision prohibits only levy of a tax and not a fee. This is because the purpose of a fee is to control secular administration of religious institutions and not to promote or maintain religion. Thus, a fee can be levied on pilgrims to provide them some special service or safety measures. Similarly, a fee can be levied on religious endowments for meeting the regulation expenditure. 4. Freedom from attending religious instruction. Under Article 28, no religious instruction shall be provided in any educational institution wholly maintained out of state funds. However, this provision shall not apply to an educational institution administered by the state but established under any endowment or trust, requiring imparting of religious instruction in such institution. Further, no person attending any educational institution recognized by the state or receiving aid out of state funds shall be required to attend any religious instruction or worship in that institution without his consent. In case of a minor, the consent of his guardian is needed. Thus, Article 28 distinguishes between four types of educational institutions. A. Institutions wholly maintained by the state. B. Institutions administered by the state but established under any endowment or trust. C. Institutions recognized by the state. D. Institutions receiving aid from the state. In A. Religious instruction is completely prohibited while in B. Religious instruction is permitted. In C. and D. Religious instruction is permitted on a voluntary basis. Cultural and educational rights. 1. Protection of interests of minorities. Article 29 provides that any section of the citizens residing in any part of India having a distinct language, script or culture of its own, shall have the right to conserve the same. Further, no citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, or language. The first provision protects the right of a group while the second provision guarantees the right of a citizen as an individual irrespective of the community to which he belongs. Article 29 grants protection to both religious minorities as well as linguistic minorities. However, the Supreme Court held that the scope of this article is not necessarily restricted to minorities only. as it is commonly assumed to be. This is because of the use of word section of citizens in the article that include minorities as well as majority. The Supreme Court also held that the right to conserve the language includes the right to agitate for the protection of the language. Hence, the political speeches or promises made for the conservation of the language of a section of the citizens does not amount to corrupt practice under the Representation of the People Act, 1951. 2. Right of minorities to establish and administer educational institutions. Article 30 grants the following rights to minorities, whether religious or linguistic. A. All minorities shall have the right to establish and administer educational institutions of their choice. B. The compensation amount fixed by the state for the compulsory acquisition of any property of a minority educational institution shall not restrict or abrogate the right guaranteed to them. This provision was added by the 44th Amendment Act of 1978 to protect the right of minorities in this regard. The Act deleted the right to property as a fundamental right. Article 31. C. In granting aid, the state shall not discriminate against any educational institution managed by a minority. Thus, the protection under Article 30 is confined only to minorities, religious or linguistic, and does not extend to any section of citizens, as under Article 29. However, the term minority has not been defined anywhere in the Constitution. The right under Article 30 also includes the right of a minority to impart education to its children in its own language. Minority educational institutions are of three types: A. Institutions that seek recognition as well as aid from the state. B. Institutions that seek only recognition from the state and not aid. And C. Institutions that neither seek recognition nor aid from the state. The institutions of first and second type are subject to the regulatory power of the state with regard to syllabus prescription, academic standards, discipline, sanitation, employment of teaching staff and so on. The institutions of third type are free to administer their affairs but subject to operation of general laws like contract law, labor law, industrial law, tax law, economic regulations, and so on. In a judgment delivered in the Secretary of Malankara Syrian Catholic College Case 14A, 2007, the Supreme Court has summarized the general principles relating to establishment and administration of minority educational institutions in the following way. 1. The right of minorities to establish and administer educational institutions of their choice comprises the following rights. I. To choose its governing body in whom the founders of institution have faith and confidence to conduct and manage affairs of the institution. 2. To appoint teaching staff, teachers, lecturers and he-masters principals, as also non-teaching staff, and to take AC if there is dereliction of duty on the part of any of its employees. 3. To admit eligible students of their choice and to set a reasonable fee structure. And 4. To use its properties and assets for the benefit of the institution. 2. The right conferred on minorities under Article 30 is only to ensure equality with the majority and not intended to place the minorities in a more advantageous position vis-a-vis the majority. There is no reverse discrimination in favor of minorities. The general laws of the land relating to national interest, national security, social welfare, public order, morality, health, sanitation, taxation etc., applicable to all, will equally apply to minority institutions also. 3. The right to establish and administer educational institutions is not absolute, nor does it include the right to maladminister. There can be regulatory measures for ensuring educational character and standards and maintaining academic excellence. There can be checks on administration as are necessary to ensure that the administration is efficient and sound, so as to serve the academic needs of the institution. Regulations made by the state concerning generally the welfare of students and teachers. Regulations laying down eligibility criteria and qualifications for appointment, as also conditions of service of employees, both teaching and non-teaching. Regulations to prevent exploitation or oppression of employees, and regulations prescribing syllabus and curriculum of study fall under this category. Such regulations do not in any manner interfere with the right under Article 30. 1. 4. Subject to the eligibility conditions qualifications prescribed by the state being met, the unaided minority educational institutions will have the freedom to appoint teachers lecturers by adopting any rational procedure of selection. 5. Extension of aid by the state does not alter the nature and character of the minority educational institutions. The conditions can be imposed by the state to ensure proper utilization of the aid. without however diluting or abridging the right under Article 30. 1. Right to constitutional remedies. A mere declaration of fundamental rights in the Constitution is meaningless, useless and worthless without providing an effective machinery for their enforcement, if and when they are violated. Hence, Article 32 confers the right to remedies for the enforcement of the fundamental rights of an aggrieved citizen. In other words, the right to get the fundamental rights protected is in itself a fundamental right. This makes the fundamental rights real. That is why Dr. Ambedkar called Article 32 as the most important article of the Constitution, an article without which this Constitution would be a nullity. It is the very soul of the Constitution and the very heart of it. The Supreme Court has ruled that Article 32 is a basic feature of the Constitution. Hence, it cannot be abridged or taken away even by way of an amendment to the Constitution. It contains the following 4 provisions. A. The right to move the Supreme Court by appropriate proceedings for the enforcement of the fundamental rights is guaranteed. B. The Supreme Court shall have power to issue directions or orders or writs for the enforcement of any of the fundamental rights. The writs issued may include habeas corpus, mandamus, prohibition, certiorari and quo warranto. C. Parliament can empower any other court to issue directions, orders and writs of all kinds. However, this can be done without prejudice to the above powers conferred on the Supreme Court. Any other court here does not include high courts because Article 226 has already conferred these powers on the high courts. D. The right to move the Supreme Court shall not be suspended, except as otherwise provided for by the Constitution. Thus the Constitution provides that the President can suspend the right to move any court for the enforcement of the fundamental rights during a national emergency. Article 359. It is thus clear that the Supreme Court has been constituted as the defender and guarantor of the fundamental rights of the citizens. It has been vested with the original and wide powers for that purpose. Original, because an aggrieved citizen can directly go to the Supreme Court, not necessarily by way of appeal. Wide, because its power is not restricted to issuing of orders or directions but also writs of all kinds. The purpose of Article 32 is to provide a guaranteed, effective, expeditious, inexpensive and summary remedy for the protection of the fundamental rights. Only the fundamental rights guaranteed by the Constitution can be enforced under Article 32 and not any other right like non-fundamental constitutional rights, statutory rights, customary rights and so on. The violation of a fundamental right is the sine qua non for the exercise of the right conferred by Article 32. In other words, the Supreme Court, under Article 32, cannot determine a question that does not involve fundamental rights. Article 32 cannot be invoked simply to determine the constitutionality of an executive order or a legislation unless it directly infringes any of the fundamental rights. In case of the enforcement of fundamental rights, the jurisdiction of the Supreme Court is original but not exclusive. It is concurrent with the jurisdiction of the High Court under Article 226. It vests original powers in the High Court to issue directions, orders and writs of all kinds for the enforcement of the fundamental rights. It means when the fundamental rights of a citizen are violated, the aggrieved party has the option of moving either the High Court or the Supreme Court directly. Since the right guaranteed by Article 32, i.e., the right to move the Supreme Court where a fundamental right is infringed, is in itself a fundamental right, the availability of alternate remedy is no bar to relief under Article 32. However, the Supreme Court has ruled that where relief through High Court is available under Article 226, the aggrieved party should first move the High Court. Writs types and scope. The Supreme Court, under Article 32, and the High Courts, under Article 226, can issue the writs of habeas corpus, mandamus, prohibition, certiorari and quo warranto. Further, the Parliament, under Article 32, can empower any other court to issue these writs. Since no such provision has been made so far, only the Supreme Court and the High Courts can issue the writs and not any other court. Before 1950, only the High Courts of Calcutta, Bombay and Madras had the power to issue the writs. Article 226 now empowers all the High Courts to issue the writs. These writs are borrowed from English law where they are known as prerogative writs. They are so called in England as they were issued in the exercise of the prerogative of the king who was, and is still, described as the fountain of justice. Later, the High Court started issuing these writs as extraordinary remedies to uphold the rights and liberties of the British people. The writ jurisdiction of the Supreme Court differs from that of a High Court in 3 respects. 1. The Supreme Court can issue writs only for the enforcement of fundamental rights, whereas a High Court can issue writs not only for the enforcement of fundamental rights but also for any other purpose. The expression "for any other purpose" refers to the enforcement of an ordinary legal right. Thus, the writ jurisdiction of the Supreme Court, in this respect, is narrower than that of High Court. 2. The Supreme Court can issue writs against a person or government throughout the territory of India, whereas a High Court can issue writs against a person residing or against a government or authority located within its territorial jurisdiction only, or outside its territorial jurisdiction only if the cause of action arises within its territorial jurisdiction. 15. Thus, the territorial jurisdiction of the Supreme Court for the purpose of issuing writs is wider than that of a High Court. 3. A remedy under Article 32 is in itself a fundamental right, and hence, the Supreme Court may not refuse to exercise its writ jurisdiction. On the other hand, a remedy under Article 226 is discretionary, and hence, a High Court may refuse to exercise its writ jurisdiction. Article 32 does not merely confer power on the Supreme Court as Article 226 does on a High Court to issue writs for the enforcement of fundamental rights or other rights as part of its general jurisdiction. The Supreme Court is thus constituted as a defender and guarantor of the fundamental rights. Now, we will proceed to understand the meaning and scope of different kinds of writs mentioned in Articles 32 and 226 of the Constitution. Habeas corpus. It is a Latin term which literally means to have the body of. It is an order issued by the court to a person who has detained another person, to produce the body of the latter before it. The court then examines the cause and legality of detention. It would set the detained person free, if the detention is found to be illegal. Thus, this writ is a bulwark of individual liberty against arbitrary detention. The writ of habeas corpus can be issued against both public authorities as well as private individuals. The writ, on the other hand, is not issued where the detention is lawful. B. The proceeding is for contempt of a legislature or a court. C. Detention is by a competent court. And D. Detention is outside the jurisdiction of the court. Mandamus. It literally means we command. It is a command issued by the court to a public official asking him to perform his official duties that he has failed or refused to perform. It can also be issued against any public body, a corporation, an inferior court, a tribunal or government for the same purpose. The writ of mandamus cannot be issued a. Against a private individual or body. B. To enforce departmental instruction that does not possess statutory force. C. When the duty is discretionary and not mandatory. D. To enforce a contractual obligation. E. Against the President of India or the state governors. N. F. Against the Chief Justice of a High Court acting in judicial capacity. Prohibition. Literally, it means to forbid. It is issued by a higher court to a lower court or tribunal to prevent the latter from exceeding its jurisdiction or usurping a jurisdiction that it does not possess. Thus, unlike mandamus that directs activity, the prohibition directs inactivity. The writ of prohibition can be issued only against judicial and quasi-judicial authorities. It is not available against administrative authorities, legislative bodies, and private individuals or bodies. Certiorari. In the literal sense, it means to be certified or to be informed. It is issued by a higher court to a lower court or tribunal either to transfer a case pending with the latter to itself or to squash the order of the latter in a case. It is issued on the grounds of excess of jurisdiction or lack of jurisdiction or error of law. Thus, unlike prohibition, which is only preventive, certiorari is both preventive as well as curative. Previously, the writ of certiorari could be issued only against judicial and quasi-judicial authorities and not against administrative authorities. However, in 1991, the Supreme Court ruled that the certiorari can be issued even against administrative authorities affecting rights of individuals. Like prohibition, certiorari is also not available against legislative bodies and private individuals or bodies. Quo warranto. In the literal sense, it means by what authority or warrant. It is issued by the court to inquire into the legality of claim of a person to a public office. Hence, it prevents illegal usurpation of public office by a person. The writ can be issued only in case of a substantive public office of a permanent character created by a statute or by the Constitution. It cannot be issued in cases of ministerial office or private office. Unlike the other four writs, this can be sought by any interested person and not necessarily by the aggrieved person. Armed forces and